Okay? There are two types of licensing statutes generally. This is where you run a business or an occupation or profession and you're required to have a license in order to do so. I think we've talked about this before. Some licensing statutes are only for taxing or raising funds for the government. That's the only purpose that they really serve. So if you open a business and you're required to have a license and you post that license on your wall, it's probably one that's only required for taxing purposes. However, if you're in a certain trade or profession, that's different. So if you're a cosmetologist and you have to have a license from the state in order to do that kind of trade or profession, then that is not just for raising taxes, that is in order to regulate the profession or the trade, to make sure that the person doing that work is competent. So usually you have to pass tests, have a certain kind of education, etc. So basically the rule is that if it's a taxing statute only and you don't have the license, it's not going to void the contract. On the contrary side, if it's a regulatory license, it's going to have some effect on the contract. It's usually going to be illegal and unenforceable. Okay. Another area where contracts may be illegal and unenforceable is where they're against public policy. Examples of that are contracts in restraint of trade, covenants not to compete, and the sale of an ongoing business. We're going to talk more about covenants not to compete later, but basically a covenant not to compete is a contract that an employee signs with an employer agreeing that if they leave employment, that they will not compete, open a similar business competing with the employer. Courts have generally ruled that those kinds of covenants in a contract are legal and make the contract valid only if the time period for the restraint and the geographic range of the restraint are reasonable. And that's going to be a case-by-case situation depending upon the profession or trade and the given circumstances. Okay? All right. Unconscionable contracts. This is a very difficult area. In a long time ago, the rule of unconscionability was something that was very rarely, if ever, applied by courts. But basically, unconscionable means that the contract was so overbearing and that the position of the parties in negotiating the contract was so, one party was so strong and the other party was so weak that it makes the contract unconscionable. So some of the factors that the courts look at in considering this are what are the bargaining powers of the party. With regard to the contracting party who may be buying a service or a product, does that person have any other options? If they have no other options, it makes it more likely it's going to be unconscionable because they were kind of forced into the contract. What are the terms of the contract? Are they burdensome on one party and extremely favorable on the other party? Those are some of the things that a court will look like, and in rare situations the court might hold the contract unconscionable. But generally courts still work from the premise that if two people are bargaining in good faith in fairly equal or fairly free bargaining positions at arm's length, then the courts are not going to interfere with what they bargained for and exchanged. As we said before, the sort of peppercorn theory, we're not going to look at the value or the consideration because we presume that the people are negotiating in good faith. And if a person makes a bad deal, that's just too bad. Okay? So that's all I'm going to talk about unconscionability, although we have more slides on it. Exculpatory contracts. This is an interesting area. I'm not an expert in this area, but it's a bothersome area. Exculpatory contracts are contracts where you sign something saying you release the other party from liability for anything they do. Often, these contracts violate public policy and are not enforceable. However, what you're going to find is that they're all over the place. Okay, every summer I go up to the Ocoee River and go whitewater rafting with my stepson and his fiancée. And they always make us sign something that says that if anything that happens to us, the outfitting company is not liable. However, I am concerned that that may not be enforceable if what they do is negligent or gross negligence, and I'm not sure what the standard would be. I haven't done any recent research on it. But just understand for our purposes that exculpatory clauses in contracts can be enforceable, but they may also not be enforceable if they're against public policy. Okay? I used to love it when people would come to me as a lawyer and they'd say, would you draft us a release, or not really a release, but a contract, an exculpatory clause. Usually it involved things like a field trip for children for a church or something like that, where the church would not be held liable. Okay. Now, we're going to move on to other issues regarding contracts. And now we're going to talk about the form of a contract. First of all, as we said before, the general rule is that contracts do not have to be in writing. They can be oral or written. However, some contracts are required to be in writing, and that is usually under what's known as the Statute of Frauds, which was a statute first enacted in England and then carried over to U.S. law. The Uniform Commercial Code has a Statute of Frauds, and oftentimes there's a statutory Statute of Frauds that applies to contracts not covered by the Uniform Commercial Code. And basically what that says is that certain contracts have to be in writing or some modern equivalent to writing, such as an electronic equivalent. So if the contract is not in writing and is covered by the Statute of Frauds, then it's not enforceable in a court. The purpose of this is to prevent harm to innocent parties by requiring written evidence of agreements concerning important transactions. Here are some of the ones that have to be in writing in virtually every state. Contracts involving the interest in land, so the sale of land usually has to be in writing. Contracts that cannot by their terms be performed within 1 year from the day after the date of formation of the contract. Collateral or secondary contracts. Promises made in consideration of marriage and under the UCC for the sale of goods, for contracts for sale of goods priced over $500. Okay, the concept of privity. Privity basically means the parties that are entering into the contract, as opposed to a third party who may have some legal involvement or interest in the contract. So there are situations where two parties can enter into a contract, and then the contract can result in some third party having either what we call rights or duties under the contract. So this allows a party to a contract to transfer the rights or duties from the contract to another person through an assignment or a delegation. So if a party to a contract is assigning their rights to a contract or is passing those along, it's called an assignment. If a party to a contract is passing along to a third party their duties, then that's a delegation. Another type of third-party contract is a third-party beneficiary contract. Here, neither the rights nor the duties are being passed on to a third party, but simply the contract is formed by two parties for the benefit of a third party. Okay? So, for example, if I have an 18-year-old child, or an adult at 18, and I pay somebody to tutor